And when asked, he says, yes, I can see the notice doesn't have particulars, but indeed those particulars were given. And so the question is, what happened to those particulars? So, but the bottom line is this: the notice that was moved on 13th, as you look at it today, did not have details and particulars. The motion was not moved under the provisions of Section 15 of County Government Act and the standing orders of Kisii County Assembly, standing orders number 197 and 198. With all those considerations, my colleagues have told you that please, when you go into those technical issues, treat the technical issues as non-issue because the defense, Dr. Monda's defense, have acquiesced by bringing witnesses. And so I would want to ask the question then, what were we supposed to do? Were we supposed to just come and smile and not do anything? One. Number two, we raised those issues at the start of these proceedings, and the ruling asked us that the issues you are alleging, the question of whether or not it was on time, whether or not it had particulars, whether or not it was moved properly, are issues that we'll have to determine after listening to the facts. And so we are saying that by presenting witnesses, we were not acquiescing nor abandoning our preliminary issues. We were doing what the ruling of this Senate said, being that demonstrate the basis of those technical arguments through the facts that you will adduce, and we have demonstrated that spectacularly through both cross-examination of the witnesses of the county assembly and through our own witnesses confirming that each of those wrongdoings happened. Now, I am aware that a number of senators have said that we should, based on the provisions of Article 152 of the Constitution, 159 of the Constitution, we do not want to look at the technicalities. And then on our part for the Deputy Governor, then we would want to ask you, what was the purpose then of the rules? Why are we sitting, why did we sit yesterday up to midnight? Why are you sitting past hours today? Isn't it because the law prescribes that some things are to be done within time? Isn't it because you are being faithful to timelines? And if you, at this national level as senators, are prepared to go out of your way and comply with the law, why should you give latitude to county assemblies to say, we will smilingly disobey the timelines that have been set and it shouldn't matter? Why should you extend that latitude? And most especially when those county assemblies do not come and say, oh, sorry, we were out of time because there was an earthquake. They are not saying we are out of time because there was COVID outbreak. They are not giving any reason or any excuse for why they are out of time. We pray that for purposes of standardization of the rights of the parties, for purposes of the rule of law, you do insist that unless there is a good reason why you should invoke the provisions of Article 159 and entertain issues and say it is a technicality. Before you do that, a justification needs to have obtained, and that justification and the law allows for that extension. We submit that the law does not allow anywhere for that extension of time. And therefore we pray that you do reject the motions for lacking particulars, for mutating from the date of 13th when the notice was issued, and mutating into something different by the time it was being moved on the 21st as a different motion, and for not having been moved properly. We pray that you do be faithful to the law that is keeping you seated here today up to this time and yesterday also. You do enforce that law and say that motion is null and void to that extent. Now, I am aware that the probability is that the county assemblies have been casual about it. I would pray that the Senate, in developing jurisprudence, do not encourage that feeling that it doesn't matter. All we need is to just throw anything in the face of the Senate, and the Senate will readily entertain it. That you do say everybody must follow the law, and that otherwise the rights of parties, including Dr. Monda, will stand violated. I would like then at this point to cede the few remaining minutes to my colleague, Mr. Ochoki, But before I do that, I would just like to cover one other issue on the issue of public participation. I've already pointed out to